within 10% within 2 weeks, another 10% within next 1 week, and remainder 10% within 1 week. They are not deposited.
Date of e-auction is 15/12.
They're not deposited the amount. Clear, Nanja Reddy? Because the matter is listed for non-compliance of office objections. Yes. Serial number 11. Learned counsel for the respondent number 4. 3. Respondent number 3 submits. The writ appeal does not survive for consideration. 2 reasons. Firstly, no amount as directed by this court in the order impugn has been deposited. But that is not stayed here so far. Yes, but now that has come to an end. And the said time fixed by the court has expired. Secondly, the e-auction was held on 15th December, 15th December 2021. No bidders came forward. It's the e-auction notice dated 11/11/2021 may not survive. But there are other reliefs claimed in the petition. Hence, a challenge to the e-auction dated so may not survive. It is a subject matter of this writ appeal. This is a matter for hearing of the appellant counsel on February 2021. To hear on fitting, keeping open the office objections.
May I please, the lordships? In this case, we have already clarified, Millard, that we cannot be able to produce the color photos of Xerox copies that was given to me by the respondent, Millard. Your lordship may be aware of the Tenali Rama story, Millard, where a black dog is thought to be converted into a white dog. Same thing is office has asked me to produce color photos of Xerox.
That is the only office objection.
Yes, my other office objection has been overruled, Millard.
It's office objection.
Clarify, Millard. I had clarified, Millard, to the High Office.
Yes, what is the merits of the case?
Yes, ma'am. Merits, Millard. With an intention to establish. Yes, Mr. Keshav, but and the other contesting respondent is Mr.
This is the matter for preliminary hearing by 15th.
Can I take out notice, Mr. Kantaraj? He appears for the contesting respondent number 7.
The Kantaraj.
Yes, ma'am. Kantaraj appears for respondent number 7. Minute. There are two contestants.
We will list the matter on 15th, then we will see, sir. Yes,
15th for admission minutes?
Yes, for preliminary hearing. Yes.
Grateful to your lordships. Office objection is overruled, means?
Yes, overruled.
Grateful to your lordships.
Yes. Check whether it is the only office objection. Yes. Yes. Yes, IA2 of 2021 stands dismissed as not pressed. I wanted to remove the office objections. This is the matter week after next Thursday.
I represent the petitioner appellant Miller. In this case, respondent number 6.
No, you can kindly use the mic, sir. Some learned counsel is representing through video conferencing. Let him also
In
hear
this
it.
case, Miller, respondent 6 died on 11/21/22. I am making an application. Respondent number 6, Sanjeeva died. I am making an application to bring the LRs on record. Respondent 6.
Kindly wait, sir. Kindly wait, sir.
Challenging of the remand, but after remand they participated. Metropolitan Magistrate, and in your they participated and final order passed on 12th April.
Who is appearing for the appellant?
I represent the appellant, Miller. I represent the appellant. In this case, Miller, respondent 6, the contesting respondent is dead. On 21/22, I am making an application to bring the LRs on record. 20th of January 2022. Respondent number 6 in WA 2025 and respondent 6 in WA 2024. I want
So,
to
learned counsel for the respondent. Learned counsel for the respondent. The other respondent submits that this writ appeal does not survive for consideration.
I will let the parties come on record. He is one of the main contesting parties.
That is Sanjeevappa.
Yes, ma'am. He is also interested.
No, he may be interested now. The respondent number 6 is dead.
Yes, ma'am. 6 in the first appeal and 9 in the second appeal.
No, his name is Mr. Sanjeevappa.
Yes, ma'am. I am making an application today itself in the office.
What is your submission, sir?
My submission, my lord, they have challenged in this writ appeal regarding remanding of the matter to the Chief Metropolitan Magistrate for Proceedings. After the remand, that they have participated before Metropolitan Magistrate, final order was passed on 12th April 2000.
Pass it on.
They themselves participated.
You are appearing for whom, sir?
I am calling for I do in the district level. Here I am taking submission. Order was passed in the 80s and the first respondent, the contesting party is by the reputation, I by the reputation. After considering all those things, the report has been passed the order. After passing the order, the present appellant has participated in complaints of the petition before the High Court, that is the magistrate court, and final order has been passed on 12/4/2018. And during pendency of this case, they sought the interim order of stay of my case, my lord. Since last 12 years, I cannot recover the money, my lord. This is one-year property. Where I have to public fund, even 1 rupee I have to calculate, I have to answer to the public, my lord.
It's a return because the order passed by High Court. That is not challenging. That is the final already more. Issue LR notice, it will drag once again.
This is to participate further, my lord. Because the final test come on 12/4/2018. This appellant has never challenged. We are middle of.
Still, there is time for him to bring the LRs of the disease response number 6 on record.
Your lordship kindly see there only what they sought. Set aside one moment I brought the most of the report, my lord. Kindly see what is the.
No, Mr. Counsel, can any order to be passed against dead person?
No, not against that person. There is no order against that person.
Now, if we have to pass, no, kindly answer our question. If you pass the order now in this writ appeal, that order would be against the dead person also, respondent number 6, who is no more.
There is no order against him, my lord.
He is a party to the proceedings. Can we delete him?
He did not be a party.
No, no,
Because he saw contested even before the report.
Can we delete him? Can we delete him?
In such case, can I make one submission, my lord? This stay order may be vacated.
Yes, we will
Stay
vacate.
order may be
We will
vacated.
vacate the stay
Go
order.
ahead, because last 10 years. I
We
cannot
will vacate the stay order. That we can do.
Yes, ma'am. Yes, sir.
ಇಲ್ಲ ನೋ ಸ್ಟೇ ನೋ ಸ್ಟೇ ಮಿಲರ್.
That
Because they themselves argued before the trial. After remand.
now let us see the order passed by the learned single judge. What is the order?
Yes, second portion they could same not move back to the order.
The opportunity to be given to all parties.
The TV is dead and the respondent number 6. Forty.
Number 40, in number 40.
Yes.
Animal. That in view of the order taken also, let us say, the ministry is directed to restore by all parties. The London magistrate also take as the first date of appearance without notice being expired. The London magistrate shall thereupon regulate the proceedings and conclude the same expeditiously as on in accordance with law, but not later
So
than
this
3
is
months.
section 14 application. Section 14 application.
70.
This third party is not a borrower, not a land, nothing to do with the property. This is not a submission. I am second creditor. Even you are the London magistrate.
She was the respondent number 10.
I am the respondent number 1 here.
Appellant was the respondent number 10. Who filed the writ petitions?
No, myself and borrower has filed. Bank and borrower has filed.
Two sub-petitions.
Here, this matter, Gabriel Raj is the borrower, he has filed a petition. In another petition, myself, bank has.
So in that petition, she was the respondent number 10. Who is she? Who is she? What is her locus?
Yes, ma'am.
She was waiting the ownership right? It cannot be disputed. It cannot be adjudicated. So it was remanded. That was negative by the court. Once again, the order party. Then verify party submit. After once the order after verification, and told that the bank can take the property in question and after the property. And then section 14.
So respondent number 6 here is a borrower.
And Raju is the
Is a
borrower.
borrower.
I am the.
Now the bank has to proceed against respondent number 6.
Company is settled by a company.
So,
Even Raju is the director of a company, my lord. Presentation before the case, notice has been not served.
No, this Sanjeev Appa.
As to an owner of the property.
So now Sanjeev Appa is no more. Respondent number 6 here.
Yes, ma'am.
He is a borrower.
No, he's not a borrower. He's not nowhere connected to the bank.
earlier property owner.
As to an owner of my mortgage property.
Who represented that the respondent number 6 before the writ court? Shyam Prasad, KV Shyam Prasad. Then you take notice for the LRs, we will close it. Who represented Sanjeev Appa? You take a notice for LRs. We'll permit him to bring the LRs of the deceased respondent number 6 on record. Yes. You file an application, huh? Yes. No, let the records be straight, sir. Let him file the objection. Let him file the application next week. Huh.
The email line.
Yes.
Okay.
Learned counsel for the appellant submits the respondent number 4. Sorry, respondent number 6 died on 20th January 2022. 6 short accommodation to file the necessary application to bring the LRs of the deceased. Respondent number 6. Learned counsel Shri K.V. Shyam Prasad submits that he undertakes to file power on behalf of the LRs of the deceased. Respondent number 6. 6 respondent number 9. Sir, we will pass the order in this writ appeal. Now let it not be there not be any ambiguity. Yes, this is in writ appeal number 2025 of 2017.
And the other appeal, it is respondent
Sir,
number 1.
appeal automatically it is the respondent number 9. Yes.
Secondary case, I am referring for respondent number 5.
A week's time granted. The appellant to file the necessary application. LR application, appellant has to file it, sir. You are the appellant. Your senior counsel is through virtual mode. Then file it, sir. Then we can take it on record. Yes, sir. We'll pass our, let it be number.
No, it may be heard
That
next week.
application will be number. No, sir.
It
If
may be
it
heard
is
next
already,
week.
it is ready, sir.
No,
Your colleague is here before the court, sir.
No, correct. It may be heard next week. I am not saying that it may be heard next week. I have no objection. It may be heard next week. Application will be filed in the course of the day.
Why should we adjourn the matter by next
No,
week?
because
There
I
is
will
no
get ready
point
because
in
I
adjourning the matter.
only to file the application. I will get ready next time, next week, my Tuesday or last week I have it. I will get ready and argue the matter on merits. No problem at all. It is
Colleague is
maintainable.
here.
If last week I have next
And
week.
it comes for the appellant. Your good name, sir? Ramachandra has filed, appearing for the appellant, has filed IA.
We have not filed the IA, and this person also not filed the IA.
Has filed IA under Order 22, Rule 4, read with Section 151 of CPC to bring the LRs of the deceased respondent number 6 on record. The learned counsel for the Mr. Shyam Prasad appearing for the respondent number 6. Who is filing? Who undertakes to file the power? Shyam Prasad undertakes to file the power on behalf of the legal representatives of the deceased respondent number 6. This is the matter on 14th February for preliminary hearing as prayed. 15th you want it. Let it be on 15th. Registered to show the name of the learned counsel Shri M.K. Venkat Ramana. For Venkat Ramana. For respondent number 1 bank. In the writ appeal number 2025 of 2017. So we will say for the bank, the ranking varies here. Registered to show the name of the learned counsel Venkat Ramana for the State Bank of India. The respondent number 1 in writ appeal number 2025 of 2017 and respondent number
Second matter, respondent number 5.
respondent number 5 in writ appeal numbers. What is that writ appeal number?
2024.
2024 of 2017. Yes.
Not taking of steps for deceased alternate. I know, but alternate is also there.
Martin, who is R10? He's also dead, huh? In the cause list, it is shown as non-taking of steps in respect of business respondent number 10 by advocate for appellant. By the order dated 2019, this respondent number. So no, sir, this respondent number 6, he died in the year 2022. This is why court officer order sheet. Kodi.
Satyanarayana Raju.
All of the are fine.
Satyanarayana Raju is no more. Then appellant has to take steps in respect of Satyanarayana Raju also.
I'll take steps.
Yes. The net counsel for the appellant has to take steps in respect of respondent number 10, Shri A. Satyanarayana Raju. Respondent number 10 in writ appeal number 2024 of 2017. It is shown so in the cause list, sir. Kindly look at the cause list. R10 in writ appeal number 2024. This is the matter by next week. You have to file an application,
Yes,
sir.
I'll
You
file the
are
application.
appearing, huh?
We'll file the application with that.
Now, who represented the Satyanarayana Raju before the learned single judge? You will undertake. Huh? Yes. Let him file the application, then we will consider it.
You take on the Kanave IA numbers master.
No, if one learned counsel is appearing to virtual mode, another counsel appearing to physical mode for the same party. Yes, yes. It's very difficult to comprehend the things.
Sorry, Mila.
Yes,
Come to you.
yes, next matter.
I appeal for the appellant in this case, my lord. My lord, weeks time may be granted, my lord, for write a letter to client.
And
My lord.
granted
When
to
will file?
do the needful. Yes, same 2 weeks time granted to do the needful. 2 weeks time granted to do the needful. Yes.
Lord, I represent the appellant, my lord. I request for 2 weeks time for the region, my lord. There was a
Yes, 2 weeks time is granted, sir. Fix. Maintainability of writ appeal. Where is Mr. Dhananjay? 13%. Where is it? Correct, sir. We'll pass over. Let us see. Pass over.
My lord, we have already taken steps on 5th of this month, my lord. 5th, we have paid the PF.
Please said to have been done office to verify. That is the only office objection. Production of translated copies. Production of translated copies of annexures is dispensed with at present. I give 1 of 2021 stands dismissed as not pressed. What is the matter? Now, where is Annexure G, the endorsement challenge in the writ petition? Where is Annexure G, the endorsement challenged in the writ petition? Where is it? Which page? 47. Huh? What is the endorsement?
Endorsement was at the time of retirement, at the time of getting pensionary benefits, we told the excess amount of which was paid by considering the place of 50 as Maleshwaram division. That excess amount was recovered and submitted the representation for payment of that excess amount. That was rejected by the appellant. That is the endorsement.
That is the single judge has considered the judgment of the Honorable Apex Court in Rafi Mashi's case, even if on a wrong notion, if any excess amount is paid.
Yes. Circumstances are different in the Honorable Supreme Court judgment. That is in that case, the facts and circumstances are different from our case. That case, inquiries in that case were entitled to the
Now, recovering this amount, which is already paid, that is adjusted on the ground of excess payment of HRA. Yes, would it be permissible?
Yes, my lord.
Yes, how it is permissible?
Regulation of the AEB employees regulation.
Yes. Yes. Yes.
65F. Regulation 65F.
Yes.
House rent allowance and city compensatory allowance are payable with reference to the place of duty.
That is correct. You, according to you, have paid it wrongly. Could it be now recovered from the retirement benefits?
At the time of
Return. Yes, from the retirement benefits.
yes, my lord.
How?
Yes,
You show from your you show from your guidelines and the regulations whether it is permissible to be
My lord,
recoverable.
as per this honorable Supreme Court judgment in Chandni Prasad, my lord.
Yes.
Excess salary. Paid to the appellants due to irregular, wrong paid session. Payments were affected due to mistake of authorities concerned, but not due to misrepresentation or fraud. Hence, this is service conditions stipulate that institution shall.
Where you are reading which paragraph, madam?
My lord, 14.
Paragraph 14.
Yes.
Can you read that paragraph?
We are concerned with the excess payment of public money, which is often described as taxpayers' money, which belongs neither to the officers who have effected overpayment, nor to the recipients. We can see the concept of fraud. The question to be asked is whether excess money has been paid or not, may be due to bona fide mistake. Excess payment of public money by the government officers may be due to various reasons like statelessness, pollution, favoritism, etc. Because money in such situation does not belong to the payer or the payee. Situations may also arise where both the payer and payee are at fault. Then the mistake is mutual. Payments are being effected in many situations without any authority of law, and payments are being received by the recipients also without any authority of law. Any amount paid or received without authority of law can be recovered
No, you are entitled to recover it, but not from the retirement benefits. That is what the Honorable Apex Court has expressed, barring few exceptions. Yes, this judgment is stated 2012. And this Rafiq case, that is whitewasher case, is of the year 2015.
Where the employee were entitled to the wages in that case. In that case, may not what
You would have taken action at the appropriate time, madam. Why did you wait till his retirement? From the retirement benefits, if you want to deduct that amount and you want to adjust it, that may not be feasible.
Kindly see the
Yes.
page number 41. That is the state of Punjab. In that case, my lord, the recovery is impermissible pay. The recovery for a period of excess period of 5 years. In this case,
Not excess period of 5 years. It is from the retirement benefits, either it is 1 year or at a time of retirement, whatever the amount has to be adjusted towards the retirement benefits. From that, you cannot claim it.
here only we have recovered only 3 years HRA which was paid excess. My lord. For a period of 3 years, my lord, to work in the Nelmanga subdivision, and he has received the HRA for the CP Maleshwaram division.
No grounds for interfere with the well-reasoned order of the single judge taking as business. Also,
Lord, appear for R2, madam. I appear for the appellant. This is covered by the judgment of the Supreme Court. Reported in year 1996, Supreme Court 1579. The principle is transferee is liable to pay property tax even for a period prior to the transfer. He has questioned the endorsement, asking him to pay 52 lakhs. in that, the question whether the transfer is liable or not is not being gone into by the single judge. But they said they issued a direction. Annexure G is the endorsement issued by us. That was questioned by the first respondent.
My lord, kind leave, my lord. I apologize, my lord. My lord, this is serial number 24, my lord.
Yes.
My lord, in this matter, my lord, I am appearing for respondent number 1. I have filed a memo for disposal. There is an office objection, my lord. I will comply the office objection.
No, it's not required. Memo.
Please, my lord. My
Yes.
senior, my lord, senior is
So
went
you
to
have
his
filed a memo for disposal. Now you are backing out. When the learned counsel for the appellant is ready to argue the matter, at your instant the memo. Why did you file the memo, sir? Then, if you are not ready, memo
my
for
lord, the
disposal.
thing is, my lord, my senior is went to his native, my lord. His relative is passed
No,
away.
sir.
So, my lord, may kindly taken up on tomorrow.
We will not adjourn the matter. If it is required, we will adjourn the matter. Yes, it is based on your yes. Why you have filed the memo for disposal? On what ground? What is the submissions made in the memo?
Memo, he wants the same player what the player granted by the single judge. The same thing he has said, nothing else. Anyway, it has to be gone into, matter has to be gone into. If there's an inconvenience, it will be taken some other objection.
May kindly taken up on tomorrow, my lord. I request this honorable court, my lord. My senior relative has passed away. That's why, my lord.
Yes, list the matter. 14 February.
Much obliged.
Point number 1.
In this case, I get respondent below. This matter is admitted on 23/7/2021. That my lawyer friend asked me that is there any possibility of settlement, that I will put a word to my client for some matrimonial dispute. The matter is already admitted.
Explore the possibility of settlement if any.
Oh, bless.
I bring for appellant, my lordship. This is covered by judgment of this honorable court and honorable apex court, my lordship. Therefore, the respondent is also filed a memo for disposal. In view of the same, my lordship, it can be disposed.
Please, my lord. I'm for respondent number 192 in this matter, my lord.
What is the matter?
My lordship, this is my lordship in respect of cancellation of the sites. My lordship, we need to approach the urban development authority, my lordship, now. The government, we need to approach the government in view of the judgment rendered by this honorable court as well as the honorable apex court, my lordship.
Please, my lord. It has to remind it to the revisional authority, my lord, which is urban development department.
Mysore Urban Development Authority case.
Please, my lord. I have produced the judgment along with my memo, my lord.
So now the parties, they have to appear before the revisional authority.
Please, my
Yes,
lord.
Revisional authority, state government of.
Any time is prescribed for you to.
My lordship, some of the matter, my lordship, 30 days has been given, my lordship. Within 30 days, I have to approach.
So the delay of 1124 days in filing this appeal.
My lordship, I have stated, my lordship, the appellant is in the private job who needs to request to travel all the way from all over India, my lordship. He has instructed his father-in-law to follow up, who has suffered a paralysis, my lordship. That's why there is a delay.
It be considered as the sufficient reasons condone that huge delay, inordinate delay of 1,124 days. Is what you say? Well, respondent consent.
I have no objection, my lord, toward the delay, my lord.
What is the order of the land single judge?
Lordship, order of the land single judge, my lordship, at page number.
This is a common judgment.
Yes, my lordship. It is,
Yes, my lord.
It is a common judge.
Yes, now what happened to the other matters?
Other matters are all this kind of permission has been granted. The matter is also pending before Urban Development Authority, my lordship. They have not taken any decision yet to be taken, my lordship.
What was the dispute?
My lordship, I have granted with a site, my lordship, by the
default committed in the matter of payment of the notified allotment cost.
Yes,
first of all, you have not paid the cost, notified cost within the time fixed. You have not filed the appeal within the time.
Lordship, Honorable Apex Court has considered all the aspects, my lordship. As a one-time relief, my lordship, it has been held that you approach the Urban Development Authority, who are the competent authority to take a decision, this kind of matters, my lordship.
This kind of matters, but not with this.
Connected matters only, my lordship.
Connected matters, but not with this inordinate delay. It impose some costs. What is the value of the site?
My lordship, earlier, my lordship,
2,20,000.
2,20,000.
20,000.
You pay cost of rupees 10,000 at least minimum.
$5,000 madis. 5,000.
What is first orders and only 1 of 70? Appeal is filed with a delay of 1,124 days. Accepted. The cost shown in the affidavit accompanying the application. That is again 1 of 17. Is subject to payment of costs of rupees 3,000. Able to Minister's COVID-19 relief fund within a period of weeks from today. Main matter ಅದು. And a concept that the issue involved herein is no more recent background in view of the order passed by the Honorable Apex Court on 26 July 2016, whereby the parties are directed to appear before the Revision Authority under the provisions of the Karnataka Urban Development Authority Act 1987 and Rules 19 of the Karnataka Urban Development Authority in brackets allotment of rules 1991. The Revision Authority has been directed to pass appropriate orders in accordance with law after hearing the parties. We have perused the order, the Honorable Apex Court. Vimala SR versus Mysore Urban Development Authority in Civil Appeal number 7048 of 2016 and connected matters. Approved by the learned counsel for the parties. The matter being squarely covered by the said session. It disposed of this appeal in terms of the said order. Parties, the appellant is permitted to appear before the Revision Authority under the provisions of the Act and the First Authority Act for sure within a period of 30 days.
Yes,
And on such proceedings being initiated by the appellant authority, the Revision Authority shall pass appropriate orders in accordance with law after hearing the parties in an expeditious manner. We not deposited any money also.
No, madam.
no, my lord.
No, my lord.
My lordship, in before the Apex Court, my lordship, the parties have deposited some money which has been refunded.
That is the reason we asked you whether we have to refund the amount.
No,
which we
my
have
lordship.
deposited.
No, we have
Yes.
not deposited.
We make it clear that you have not expressed any opinion on the merits of the claims of the appellant. Rights and contentions of the parties are left open. It appeal stands disposed of accordingly.
Much.
Matter is repeated. Passing. Ready? Pass over. Yes. 31. Yes, 31.
My lord, 29 password.
Plus 31, I appear for the appellant, my lords. I request a short accommodation in this matter, my lords. 31, my lords.
Let us see the orders. At your request, the matter is listed today, sir. We will not adjourn the matter.
My request for Wednesday at least.
No, sir. On the last occasion, on 2nd, at your request, we have given a specific date, sir.
My lord, in this case, I am appearing for the
I
respondent.
request the passover at least, my lord. Passover.
My lord, may I make one submission, my lord?
Yes.
In this case, I am appearing for the respondent, my lord. As Puttayoda sir tested COVID positive, my lord, kindly grant 2 weeks, my lord, because he has been home quarantine, my lord. It's my request, my lord. Yesterday he has tested positive, my lord, corona positive, my lord.
The matter week after next.
Much obliged, much obliged.
Submitted that the learned counsel, the arguing counsel, it is submitted that the arguing counsel is not keeping well. This is the matter. Week after next, as great. How many times the matter is adjourned, sir? Kindly see the order sheet. How many times the matter has been adjourned? His uncle is in the hospital. Kindly look at the order sheet, sir. We were under the impression that you have made a submission that the arguing counsel is not keeping well. That is not so. His uncle is not keeping well. We will not adjourn the matter. Kindly look at the order sheet. No, we have made it very clear, sir. Finally, in this is not fair, sir. Recall that order. No, it should be very clear, sir. Connect counsel for the appellant. Take further 6 times. How many times? Finally, Anta, we have granted the time. We will adjourn the matter with some costs. This is the matter. 14th February. Subject to payment of costs in each case. How many cases? 2 cases. 3 cases. You are ready in 37. How much cost shall we impose? Oh, there should be some sanctity to the orders of the court. That's why we are not taking up these matters. We'll have it on Wednesday then. Ninth. Day after tomorrow, sir. So let it be on 9th February. Other happily relaxing the earlier order, the matter is subject to 9-2. 37. Sir, 3008 days in filing the appeal. First, you have to address the arguments on that application. with respondent is no more. Then this is not fair on the part of the learned counsel to give this half-baked information to the court, sir. Huh? Yes, what it? Ah, 3008 days delay in filing this appeal. How to condone it, sir? The policy of live and live, let live also to be adopted. That is the view expressed by the learned single judge. Yes. Hardship could court of this. No, sir. Kindly look at the order sheet, sir. How many times the matter has been adjourned? I cannot, whoever appears, sir, it has no relevancy here. No, sir, it's not fair. Even there is observation that in the application filed for compensation, it indicates that it has been made by the petitioner in as much as signature in the wakalat filed in this writ petition and the signature of the application differs.
extent, that's right, is limited, and some extent is given to others.
It is also true that the petitioner is not questioning the grant of occupancy rights in the respect of the other various lands, including the land in question, to an extent of 55 cents. Occupancy rights in respect of 80 and to 55 cents. What is the explanation offered for the inordinate delay of 3008 days? The appellant was not advised by the advocates who dealt the matter on earlier occasion by providing correct advice in the matter. This is the reason. It's not a sufficient reasons. The other remaining things are only on the challenge to the order of the learning single judge. Leave and let leave is not the doctrine which is applicable to the provisions. The present case, it is only the provisions of law not applicable to the present case. The only reason is that no advice was given. It is also relevant to note that the length of delay is no consequences, and the explanation offered while seeking condoning of such long length of delay would always prevail in law. It has no consequence. It's very difficult to accept it, sir. On 9th, no further adjournment. We have made it very clear, sir. As prayed by the learned counsel appearing for the appellant, it is made clear that no further adjournment would be granted on the next date of hearing. Yes.
Appear for the third respondent. Appear for third respondent.
Appear for the university.
The name is not shown here in the list.
My lord, third respondent is by me. My name is Shofo.
They filed the caveat.
No, my
They filed the
lord.
caveat.
Notice was ordered. After notice, I appeared for R3 contesting respondent. Serial number 38.
Oh, we are in serial number 41, sir.
Oh, sorry, because 37, after 37, I was waiting for this. Sorry.
T8 is the agenda 10:30 only, a week after next.
Please, ma'am, please.
Yes. Serial number 41. You're seeking time, huh? Okay, 1 of 2021 will dismiss it as not pressed. Okay, 1 of 2021 stands dismissed as not pressed. No, that is the application that you have filed for condonation of delay to be not pressed by advocate. Since writ appeal is filed in time, but that also you are objecting. Huh? Yes. Yes. When do you want it? This is the matter on putting a spray gun.
This case, I am for the respondent in this case, my lord. On last date of occasion, lordship directed me to take the instructions. My lord, as per the instructions, my lord, the appellant is not entitled for the entire length of the service, my lord. The learned single judge is rightly passed the orders. He is entitled for only maximum period of 3 years, my lord, as per 248 of KCSR, my lord. That is
Principal benefit scheme rules is not applicable.
no, my lord. It is not applicable because, my lord, he switched over to the government service after is serving in the grant in need institutions, my lord. 248 is very clearly applicable.
It is Shrikant. So,
I beg to appear for the appellant.
The respondent has been served with a copy. I am for the curator respondent. Lord, I've been served with a copy of citations now through email. Lord, week's accommodation, my lord, I look into this matter and make submission. My lord, I am for the curator respondent in this matter. 10 minutes back, my lord, I got
case for admission. I have to make out a case for admission.
There is an IFR stay.
The matter is very simple.
IFR stay because I am the sufferer here, my lord. Since 1994, even I've lost my family. I am the sole survivor. My lord, a week's accommodation, my lord, I look into the citations and make my submissions, my lord.
You have already given a copy of the citations.
Yes, no.
So file report also. Question is whether the employee is a workman or not under the idea.
That have been forwarded. I'm happy
to consider.
Mr.
I have no objection. I have no objection if it is adjourned, my lord. I have absolutely no objection for being adjourned. I am not on that.
14 February next week.
Please.
At the request of the learned counsel appearing for the aviator respondent.
Appear for the petitioner's counsel, my lord.
Yes.
The facts of the case is the present appellant was serving in Central Reserve Police, and he submitted a resignation on 25/1/2017. It was accepted on 27/1/2017. There is a provision under the law that he can seek for an cancellation of his resignation within 90 days. He opted to cancel his resignation on 21/4/2017. And the page 36 may kindly be seen, my lord. The CSR rule says that it can be withdrawn. It can be withdrawn. But the learned single judge has dismissed his writ petition, stating that he submitted his application beyond 90 days period. Hence, I have filed my writ appeal against the order of the trial court, my lord. Am I audible, my lord?
Yes, sir. Yes, sir. You are audible.
Please, my lord.
No, kindly read annexure J. It was beyond 90 days.
Please, my
It
lord.
was not within 90 days.
No, my lord. Your lordship may kindly see. He has made an application. It was accepted on 27/1/2017, my lord.
Kindly read annexure J. Kindly read annexure J.
Please, my
The
lord.
resignation was made on
You are
18/1/2018, not on 25/1, 18/1.
No, my lord. Your lordship may kindly see my representation, which I have made to the annexure G, my lord, page number 32. I'll read out that, my lord. The entire thing is there in the entire facts of the case is that in that representation. I number so and so.
Sir, before that, let us read the impugned endorsement annexure J.
Please, my lord. Your attention is drawn towards your letter dated 21/4/2017, addressed to Director General CRPF, New Delhi. In the said letter, you have sought for restoration of services. At this circumstance, it is informed to you that you were resigned from services on 18/1/2017 upon your request due to some personal reasons. Even after providing sufficient time to think over the problems which may sustain by you in future for the reasons of resignation, and upon further request for resignation from your end, resignation was accepted by the orders of the Commandant 217 Battalion, order dated 25/1/2017 with effect from 27/1/2017. Presently, you have requested to restore you in the services vide your letter under reference, but you have been informed under Rule 26 of CSRP pension rules, it is required to seek for restoration in services within 90 days from the date of submission of the resignation letter. But in your case, the stipulated 90 days of the period exceeds, for which there is no provision to restore you into services, which please note. Your lordship may kindly see the statement of objection on the next page, my lord. At para 6, my lord. That is ink page 41.
Yes, sir.
The averment set out in paragraph 4 are denied. The petitioner did not send any such request to the appointing authority within permissible period of 90 days. However, he had sent an application on 21/4/2017 addressed to DG CRPF with copies to Honorable Prime Minister and Home Minister. The representation of petitioner was entertained by DIG CRG vide their letter dated 22/5/2000. Thus, request of the petitioner was not considered as between the date of resignation and date of resuming duty as a result of withdrawal of the resignation in the instant case was for more than 90 days. His resignation was effective with effect from 21/1/2017. Hence, under the above application, he ought to have been reinstated before 27/4/2017 on an appeal by cancelling his resignation. His application was received in directorate after expiry of the above period and was thus rejected by the concerned authority. This statement is not correct, my lord. What they receive is different. I have sent a letter on 21/4/2017 before the lapse of 90 days. There is a clear explanation of the Guwahati High Court on the point, my lord. I have sent that judgment by online. It should be before your lordship, my lord. I'll just read out that judgment, my lord. There is scope even for, according to the judgment. This is the judgment of the Guwahati High Court. Navin Ram versus Union of India, reported in India Kanun.
Anyhow, sent it, sir. Yes. Is there available?
You have filed, sir. Then you have sent through the email, sir.
I have sent by email, my lord.
When, sir?
I have sent this on 8/1/22.
Is it reported judgment? You
Yes,
give us,
along with
you
the
give the number. Kindly give the details of that citation which you are referring to. We have not received it. It is not with us now.
writ petition number
Pass
6A.
it on.
Not reported.
Yes. Yes, which paragraph you want to read, sir?
Please, my lord. Para 13, my lord. At page number 3 of the judgment. 4 of the judgment. The above position now leads us to the second leg of submission of the petitioner, that in view of the executive instruction under Rule 26 of CCS Pension Rule 1972, his representation for reinstatement was submitted within 90 days of acceptance of resignation letter ought to have been accepted. The petitioner has also placed reliance on the chapter of resignation in Swami's complete manual of establishment and administration. The chapter dealing with the withdrawal of resignation has detailed the circumstances in which resignation can be withdrawn, one of which is after release. After resignation became effective, as per the said provision, the appointing authority may permit withdrawal of the resignation in case of permanent employee subject to certain conditions, one of which is that resignation and resumption of duty is not more than 90 days. The executive instruction under Rule 26 of CCS Pension Rules 1972 issued wide office memorandum dated 14/12/2007 also speaks of permissibility for withdrawal of resignation under certain conditions which as public interest subject, however, to the condition that the period of absence from the duty between the date on which resignation became effective and the date on which the person is allowed to resume duty as a result of permission to withdraw the resignation is not more than 90 days. The same office memorandum also speaks of the purpose of such provision, which is once a person relieved of his appointment on acceptance of his resignation letter, the circumstances under which the individual resigned from the post materially changed soon after his resignation, thus making the purpose of his resignation infructuous. The time limit can also be relaxed in case of exceptional cases. So my humble submission is, my lord, he is there before the authority within 90 days and he is serving the country, is hale and healthy. The authorities may be directed to consider his request in view of his application for withdrawal on 21/4/2017.
Whether in the present case it was accepted?
It was accepted, my lord. Your lordship may kindly see para 15. During the course of hearing of the writ petition, learned counsel for the petitioner, on being apprised of the factual position relating to tendering resignation of the petitioner in his own handwriting and acceptance thereof, along after 6 months, strongly emphasized on the need of the respondents to examine the case of the petitioner on the basis of immediate representation submitted by the petitioner on 21/7/2008. After acceptance of resignation with effect from 30/6/2008, seeking reinstatement in service. In the said representation, the petitioner had stated that he was shocked to receive the discharge order as he did not submit any resignation from service. However, the fact of the matter is that he had submitted resignation letter in his own handwriting and the same was accepted after about 6 months with effect from 30/6/2008. Another aspect of the matter is that petitioner was under treatment as per the own showing of the representation in their counter affidavit. The petitioner was a psychiatric patient and that he was sent on leave from 17/3/2008 to 25/5/08. On rejoining duty from leave from 13/5/08, the petitioner contained his abnormal behavior and was referred to Composite Hospital, CRPF, Guwahati for psychiatric treatment on 17/5/08, wherefrom he was released on 22/5/08 with the low medical category so and so. As stated in the counter affidavit, medical category S3 means limited tolerance to stress, has recently recovered psychoneurosis to toxic confusional states or acute psychotic reaction of turn nature. Although Director General of Assam Rifles has disposed representation made by the petitioner wide so and so, but the said order does not deal with the above aspect of the matter. The order, however, is not under challenge. As in the affidavit in opposition, this order also states about illness from which petitioner had suffered and his voluntary resignation from service. However, the fact that the petitioner had applied for reinstatement service within stipulated in a period of 90 days has not been dealt with in the order. Mr. Joshi, learned counsel for the petitioner, strenuously argued for requirement of re-examination of the case of the petitioner in the light of the aforesaid provision of permissibility to withdraw the resignation within the stipulated period of 90 days. He also submitted that presently the petitioner is fully fit to resume his duty. Considering all the above, while not interfering with the impugned order of discharge from service, the matter is remanded back to Assam Rifles Authority for examination of the petitioner afresh as to whether his prayer for withdrawal of the from the service and reinstatement service, which he had made within 90 days of acceptance of resignation and discharge from service, can be considered in view of the facts and circumstances indicated above. Let the examination be made by passing a speaking order as expeditiously as possible, preferably within 3 months. So my humble submission is, my lord, it is not the question regarding when they received the resignation letter, but the question is when it was sent. So my humble submission, this is a case for reconsideration, my lord. The authorities may be directed to reconsider it in view of this judgment, and this writ appeal may be allowed.
In the present case, when it was accepted, when 27/1 accepted.
Yes.
Accepted on 25/1/2017 with effect from 27/1/2017. This representation was filed on 21/4/2017. And when it, according to when it was filed? The what is the date? Where is the document?
Yes, madam.
41.
41. This communication has been sent elsewhere. This has not sent the abiding authority. So we cannot consider those things. And apart from that, even the rules say that they are not entitled. If the government feels that we in the public interest, it requires to be, then only he does not have a matter of right. Kindly because this is a rules itself, and also the single judge order specifically mentions that once a resignation is accepted, there is no problem to recall.
Let us see the rules.
Yes, kindly come to page number 14 minutes of the.
Now let us see the rules. Rule 26 of the Senate. Yes.
In page 62, rule 26, copy I have given, my lord. In page 62, my lord.
Right. It is crystal clear that there is no provision. One situation is under authority. Examination of accepted resignation.
In the column number clause number 4, Roman 3, subclause 3, that the period of absence from duty between the date on which the
So
resignation
at which page you are reading, sir?
page number 62, my lord, annexure R6 produced by the respondents before the learned single judgment.
That is at page 67.
Page 67, my lord.
67.
67. Sorry, my lord. Clause 20, rule 26, clause 4, subclause Roman 3, my lord. Last column, that the period of absence from the duty between the date on which the resignation became effective and the date on which the person is allowed to resume duty as a result of permission to withdraw the resignation is not more than 90 days. So on your lordship may kindly see my letter dated 21 April, my lord, at ink page 32, annexure G. The learned single judge has not considered this letter, my lord. Your lordship may kindly turn to ink page 33, last after the signature, place Shanubogana Halli, Tarikere, Chikmagalur, Karnataka, pin number so and so, dated 21 April 2017. I have sent this letter on that day, my lord. Your lordship may kindly turn to the same page, para number 3, my final request, my lord. In view of above, it is my humble and sincere request to your kind honor to consider my legitimate problems and reinstate my job and provide posting in Bangalore for next 4 to 5 years, or otherwise provide suitable pension to help me to lead a respectable life and honor my service to nation and allied force. I hope your good self will certainly gracious enough to appreciate my difficulties in right perspective and pass favorable order, for which I shall remain grateful to you. The only reason why I have been ousted from the service now, as of now, is my representation is beyond 90 days. But my case is that I have given the representation before 90 days. So let them consider the fact that it is within 90 days, and let them consider my health and other aspect by examining me. If I am medically fit, let them take me into service.
When is the acknowledgement, sir, for having submitted this representation that the 21?
They have this letter. They have your lordship may kindly see ink page 37. They have accepted that. Your lordship may kindly say ink page 37 of annexure J regarding restoration of services. Your attention is drawn towards your letter dated 21/4/2017 addressed to Director General CRPF, New Delhi. In the said letter, you have sought for restoration of services. So this one paragraph is sufficient to consider my appeal, my lord, because I am within 90 days. In page 43, they have made out a case in page 43 of the objection.
No, that is not, it is not on that ground that has been rejected. The only ground is that it is beyond 90 days. Then how do you say that it is beyond 90 days? Yes. Yes.
Apart from that, there is another point.
Yeah.
26 months. Okay.
Yes.
The only reason why I have been now present according to the understanding of the respondents.
Wait, sir, let the other side make his submissions.
Yes,
don't interfere, sir. We request you.
Please.
Yes.
26 subclass 4.
Yes.
Withdraw its resignation in the public interest on the following conditions being made.
Yes.
Actually, that you have to make sure that the authority has to consider only when there is such a thing is there. The following conditions are
Yes.
That the period of absence from duty between the date on which the resignation became effective, that is 27/1, and the date the person is allowed to resume duty as a result of permission to withdraw the resignation is not more than 90 days. What I am trying to say is not application what is submitted in 90 days. The entire thing has to happen within 90 days. We are sending to somebody where we have no authority. We are supposed to send it to the appointing authority. We are sent to State University, CH-3, where he is not an appointing authority. He has addressed the letter to Prime Minister of India. The sequence, the date of effective acceptance and the resolution, both must happen within 90 days. It is not just mere submission. That's one aspect. Second is that he has no right to say so. Only government has to say, in the interest of public, the following condition, they can take a decision. It is not that it is matter of right, we can make an application as and when he resigns from within 90 days and he requests for restoration. No, that is not the right. The rule is very clear. What was to be done is under 3, the entire exercise was to be completed within 90 days. So 3, in this particular case, 3 aspects, he said 21st year century. Yes, we are not disputing that. It has to be addressed to the appointing authority and that entire process has to take within 90 days. This letter has been reached the concerned authority beyond 90 days.
When it has reached the concerned authority?
When it's you written paragraph number 6. Paragraph 6 may be seen. Paragraph 6. The fourth line is taken. Its resignation effective is effect from 27/17 and hence under the above provision, we have to have been released before 27/4/2017 and an appeal by cancelling his resignation. He subsequently after expiry of the above period and was thus rejected by the concerned authority. Yes, already he knows where he has taken the resignation and objected. He is not under the castle, it is very clear. So it must happen within 90 days. It's not clear, it's not just clear within 90 days. And there is a restoration. What must be there within 90 days? Not a fixed instance. If the government considers on the following. In this case, what and here very clearly, candidly, it's very clear here. What is clear, what about it, there was no fact regard. Here we are very clear, here and the category in paragraph 6 of the statement of objections. And the sequence must be completed within 90 days according to the rules. That is how the 11th single judge, according to the extant rule, submitted.
No, if any delay is committed, take for that example. If there is any delay committed by the appointing authority to consider the representation submitted for withdrawal of the resignation, and that if that causes that delay ends up in considering it beyond 90 days, yes.
Here is a case. There is no representation.
No, that if you take that interpretation,
yes,
in such circumstances, what would be the effect?
Well, that's what happens is that the whole data meeting was submitted.
No, let us assume that he was submitted before the consent authority on 21/4/2017. The consent authority, if does not take any decision within 27/4/2017, then what would be the effect?
As well as because in this case, I will not go beyond that because set of facts what we are receiving is not applicable in this case. I am just answering this what I say that's
There is no?
If they don't accept it, there is matter. They need not be considered also because they can consider only on the following ground which have been mentioned in the rule itself. We cannot go beyond that. Somebody is challenge it, they did not consider different issue altogether. But it does not induce the benefit of the such person, saying that we submitted they were not considered. I have entitled. No, reason is this. The rule is very clear that it is not in entitlement. It is the conditions on fulfilling certain conditions of the rule. Government can consider. That's the only thing. There is no legal right first thing. Second argument is that it is also submitted via next day. There is another context.
Whether the time limit can be relaxed in exceptional cases?
No, right. There is no aspect which you have to look at it is, the rule is very clear. Government may and let the following conditions. And it is not a right of a person who resigns once a resident is accepted. There is man. There cannot be any second option for him to come back. Exceptional circumstances for government has a authority. That's the only possibility that we get. In this case, there is nothing.
In paragraph 14 of this Guwahati High Court judgment, it has been observed that the same office memorandum also speak of the purpose of such provision, which is once a person is relieved of his appointment and acceptance of his resignation letter, the circumstances under which the individual resigned from the post materially change soon after his resignation, thus making the purpose of his resignation infructuous. The time limit can also be relaxed in case of exceptional cases. Is it so? Then how this Honorable High Court of Guwahati has taken this exception?
Service. They have permitted, okay, look at it once again. That's the only thing. There is, according to my information, there is nothing which other they have issued the same endorsement and my inspection. Under the rules. If any order to be passed, conflict rules again you have to go back to the same problem. And these are the very disciplined forces which will have ramifications. Certainly, if it was considered a case, they would have considered. Suppose the system was not even to the appointing authority. Well, these are the people what they do is at the end, again, just to generate litigation, throw those stones. Let us see. This is not anything on the way. Require the sector in particular, they have to be deployed in the operational areas. If you start doing the evidence kind of thing, what happens? This is all of very well aware. And if they don't discharge or not discharge, they will take another allegation against the authorities. They seek for resignation. And so much of any cost and so much of time was spent on each and every person to train them to work in the legacy. Easy that I will resign. When he comes back after 3-4 months and I want to be restored. This cannot be entertained in the evolution of this kind of process. This will have a very large ramifications of security issues and decision. He was deployed after 2 years.
Is that stated in the order. Is that stated? Is that reason the
No, we will not. So I'm taking making a conduct code.
if that was stated, then
I'm not saying that.
then it would take the case out of the purview of public interest.
Yes, that's it. As far as this is concerned, this way we cannot.
On what ground he sought for withdrawal of this resignation?
He had, his wife was suffering from cancer. His mother was not well. By the time he submitted his resignation, his mother expired. Then his wife recovered. So his domestic problem came to an end. That is the reason. During the period, my mother was your lordship may kindly see page 32, my lord, annexure G, para 2. I resigned from service with effect from 27/1/2017. I joined CRPF on 19/2/2003, deputed to NSG from 15/5/2010 to 15/5/2015. During this period, my mother was a cancer patient as identified by Fortis Hospital, Bangalore. In the month of January 2015, she needed better treatment. My father, being aged, is not physically weak, but also mentally disturbed due to cancer grasped to my mother. As such, he also requires attention. Apart from the above all condition, my wife was undergoing treatment for infertility from Rockland Hospital and other hospitals. Above all this, I have to take care of my parents and wife who are fully dependent upon me. I was requesting for extension of deputation period in NSG to solve my legitimate problems, but competent authority cannot be exceeded as it is not covered under the policy issued by DOP and T on the subject, and also suggest for suitable posting after repatriation so and so dated 9/3/2015. As per the instruction of NSG, I had submitted an application through proper channel on 17/5/2015 to your office and requested for suitable postings given to me near Bangalore to solve my problem on extreme compassionate grounds. But I did not receive any reply order till my repatriation from NSG. After that, I was repatriated from NSG on so and so along with the 61 days EL en route and reported to your office on 3rd August 2015, and again submitted an application addressed to so and so, expressed my problems in the same application, requesting for suitable posting in New Delhi or near Bangalore for my mother's treatment enclosed. Copies enclosed, but my request was not considered and no reply was given to me, and posting was given at Konta, Sukma, Chhattisgarh on 14/8/2015. After availing joining time, I reported to CRPF on 28/8/2015. So and so. During interview, the commandant so and so, I expressed my grievance problem, but the commandant replied that anyone who got issued with posted to Chhattisgarh will state same kind of personal problem and ignored my request. Even at this stressful situation of my life, I continued to serve in Chhattisgarh as I had no other option. Unfortunately, I lost my mother on 5/3/2016. Death certificate enclosed. Due to this, I went into depression and lost interest in everything. But I continued to serve my nation and allied force with great respect. Meanwhile, situation at home continued to deteriorate as there was no one to take care of my aged father and pregnant wife. This increased my mental pressure. I did not get any support. After 13 years, 11 months, 8 days of dedicated selfless service, I resigned my job with a heavy heart as the situation forced me to do without any life security. Currently, me and my family are facing lot of difficulties in life. Due to this, I am unable to
do anything and facing financial hardship. I have not received any compensation from CRPF till date. In view of the above, it is my humble and sincere request to your kind honor to consider my legitimate problems and reinstate my job and provide posting in Bangalore for next 4 to 5 years, or otherwise provide suitable pension to help me to lead a respectable life and honor my service to nation and allied force.
You are not getting the pension, huh? Yes,
He's not getting anything.
Qualifying, yes, no qualifying. And this is addressed to the Director General.
Director General. Yes, my lord.
Who is your appointing authority?
Director General. Director General is the authority, and the reply is given to me by from the same.
Where is the acknowledgement, sir? Where is the acknowledgement?
Acknowledgement. Your lordship, next page, my lord, page 35. Dated 12/5/2017. Annexure H. The present request made by Shanta Kumar, so and so, dated 21/4/2017, which is forwarded to Director General CRPF New Delhi for advance action. In this regard, it is requested to take required action, or if such action is taken, kindly inform the same to the concerned applicant and directorate as well. Your lordship may kindly see Annexure G is addressed at Lodi Road, New Delhi, same office. Annexure H comes to the Special Director CRPF from Lodi Road, same office. And Annexure J, ink page 37, addressed to me, comes from the same office, Lodi Road, New Delhi. So it is all in the same office, different department. To head of the department, I have submitted my resignation on 21/4/2017, which is within 90 days, considering the acceptance of my resignation on 27/1/2017. So my grievance has to be considered by them legitimately because I am within 90 days.
days has to be calculated not from the date of you submitting the application, from the date of date coming into from the date of effective date.
27.
That is not the date, sir. If you read this
27/1/2017.
No, if you read this clause 3, 26/4/3,
yes,
that is that the period of absence from duty between the date on which the resignation became effective.
I left the duty only after 27/1/2017, after acceptance of my resignation. The resignation is their prerogative. Unless they ask me to go out of their premises, I am bound to be in service.
It was accepted with effect from 27/1/2017. So from that date, and the date on which the person is allowed to resume duty as a result of permission. So the entire process of considering your representation and giving you permission should be completed within a period of 90 days.
90 days.
That is, yes, but not, that has not been, that is not done here.
No, my lord, your lordship may kindly see.
It is not the filing of the application or giving representation should be within 90 days.
No, my lord, the judgment of the judgment of the Guwahati High Court explanation is very correct. It is within 90 days because I submitted
with great respect, sir. That is the order of the learned single judge, and if we read this 26/4/3, we may not concur with the judgment of the Honorable Guwahati High Court, sir.
My lord, my submission is only this. I am the period from which the resignation is accepted.
Now the entire gamut would revolve around this aspect. That is on 21/4/2017, the request was made, and that was forwarded by this Deputy Commander, that is the Director General Central Reserve Police Force, that is the appointing authority, the special director on 12/5/2017.
12/5/17.
Officer commanding in the battalion. He is the one who accepted resignation.
Page 60.
Page 59 can be seen, page 60 also can be seen. Undertaking. Officer commanding. Headquarters.
No, where do we get that?
Page number 60.
60.
Undertaking certificate.
Annexure R3.
R4.
R4. Undertaking certificate is annexure R4, page 65. Yes.
Officer commanding, he is the one who is the authority for it. The resignation accepted by the same officer commanding. So it has been accepted by the officer commanding in that battalion. As far as this petition is concerned, he is the one who is the officer competent to accept resignation and also consider his request. It will be done. Look at the hunting of the signature is there. Officer commanding.
Officer commanding is the appointing authority.
So what the letter is, he has sent
Where is the letter dated 25/1/2017?
In page 61, my lord, annexure R5. It is a mistake by the respondents. It should have been 2017. It is 2016. They have made. Annexure R5. Last para 4, your lordship may kindly see, my lord. Therefore, in exercise of the powers vested in the appointing authority under the provisions contained so and so, the notice for resignation from service submitted by so and so Shanta Kumar, that is the appellant of this unit, is hereby accepted and accordingly is discharged from service with effect from 27/1/2017 and struck off from the strength of this unit from the same date on 27/1/2017. So
Sir, that the representation you would have given to the appointing authorities, sir. Kindly see here your office, this office order 25th January 2017 wrongly mentioned as 2016.
Yes,
it makes it very clear that your appointing authority was one Mr. Anand Kumar Jarari, that is a commanded 217 BN CRPF. But you have given representation at annexure G2, Director General Police, Central Reserve Police, copy to Honorable Prime Minister of India, Honorable Home Minister of India. Is it permissible, sir?
My lord, is it? See, head of the institution is the person to whom I am answerable. The head of the institution will delegate the duties to his subordinates. So I have given the representation to the head of the institution well within time. And this I am bound to be in duty till I was discharged on 27/1/2017.
Had you given this representation directly to the appointing authority, that time certainly would have been considered within 90 days. You invited all this problem. Yes.
No, my lord, my submission is only this, my lord. This appointing authority, this authorities who deal with the matter, who has all are in the same office, Lodi Road.
Maybe in the same office, sir, but once the file goes to some office, how that the other officer would know? If it
No, my lord, it is not. My submission is this, my lord. My submission is this, my lord. Suppose I am giving one instance, my lord. I am giving one instance. Suppose a servant in the lower judiciary wants to set right some grievance. He can give a representation to the Registrar General. He can give a representation to the administrative judge. He can give a representation to the Honorable Chief Justice. Suppose if he gives a representation to the Honorable Chief Justice, it will be directed to either administrative judge or Registrar General. Similarly, I have given the representation to the head of my institution, who is the appointing authority. These are all the delegating powers. That cannot be a reason to oust me from the consideration of my
No, is
withdrawal
there
of the
any
resignation.
is there any provision for relaxing of these time limits
Yes,
prescribed?
I have made a research on this subject for almost 2 days, my lord. Except this judgment, I could not get anything. I could not lay my hands even on the apex court judgment. This is the judgment I got, my lord.
Especially it is very clear. It is not applicable for me. The government, if it considers, for example, one particular officer has been has resigned, it's resigned accepted. Within that period, if they consider it is worthy to take it back. That will be the period.
That to be in the public interest. Resignation from a service or a post, unless it is allowed to be withdrawn in the public interest by the appointing authority, entails forfeiture of past service. It's not in the public. Here, this endorsement itself is a wrong notion. Can you read page 38, sir? But you are, yes, you are being informed. Yes, read from presently you have been. That is wrong. That is not to seek for restoration in services within 90 days from the date of submission of resignation. It is wrong. No. Kindly read from 90. It is not like. We will read Hindi also. We will read Hindi. Yes. Yes, we will read Hindi also. What is said? इस संबंध में यह सूचित किया जाता है कि कम टू दैट लॉ वर्तमान में आपने संदर्भित याचिका प्रस्तुत कर सेवा में पुनर्बहाली हेतु अनुरोध किया है। इस संबंध में यह सूचित किया जाता है कि सीसीएस पेंशन नियमावली 1965 के नियम 26 के अनुसार सेवा से त्याग पत्र दिए जाने के उपरांत सेवा में वापस आने के लिए 19 दिनों की, दैट इज अनुसार सेवा से त्याग पत्र दिया जाने के उपरांत सेवा में वापस आने के लिए 19 दिनों की समयावधि निर्धारित है। तप्पु इदु, इट्स रॉन्ग. This 90 days not from the date of submitting the resignation, sir. You no, kindly read that this 3. That the period of absence from duty between the date on which the resignation became effective. Yes. So it is not, now you are calculated, it is from 18/1/2007. That is what you have said, sir. No means it will not cure it, sir. No, whatever your statement of objections, read Annexure J. Read Annexure J. That is the English translation. That is correct. Kindly read Annexure J, English translation, sir. It is required to seek for restoration in services within 90 days from the date of submission of resignation letter. That is what said. That is what has been said in Hindi also. अनुसार सेवा से त्याग पत्र दिए जाने के उपरांत सेवा में वापस आने के लिए, दैट इज सेवा त्याग पत्र दिए जाने के उपरांत सेवा में वापस आने के लिए 90 दिनों की समयावधि निर्धारित है, परंतु आपके मामले में 90 दिनों से अधिक सा समय बीत चुका है. So what you have said is that to resume to the duty, 90 days is the period prescribed.
आपका त्याग पत्र स्वीकार कर दिया गया, तो वर्तमान में आपने संदर्भित याचिका प्रस्तुत कर सेवा में उन्नत किया है.
No, ultimately what you have said that from the no sir, ultimately what you have said is from the date of giving the resignation letter, you have to be resumed.
That is what you have said is in your resignation letter 24/2017 के तहत बिना प्रश्न से आपका त्याग पत्र स्वीकार हुआ, तो उस दिन that's what you are saying. That's what you have said is your letter dated 24/2017. Yes, taking submission that your resignation letter is dated 25/1, your the resignation was accepted.
So 90 days period from which day to which day?
27.
But he has given it on 21/4 itself, it is within 90 days.
That's what you say that it has to be addressed to the appointing authority.
No, it is not to be addressed to the appointing authority. No, if it is addressed to the higher authority, the higher authority has to forward it to the
resignation accepted.
Yes.
By the appointing authority.
Yes.
It has to be addressed to the appointing authority only. Yes. And the time frame, if elsewhere I make a submission and
No, he has given the representation to the next higher officer. The higher officer ought to have forwarded it to the appointing authority well within time.
Actually, the rule says very clearly on the two counts. On the second count, these facts does not prove. Does not prove.
Yes.
And the consideration of this resignation request does not arise.
Yes.
On two counts.
Yes.
One, there is no problem. They are 90 days. Accordingly, it makes a claim elsewhere where it is not an appointing authority. If that is forwarded later after the time.
Don't add reasons to the order. That is not the reason stated. Don't add.
I'm not saying that it is.
That is not the reason
You have
for
said
it.
all the what you have said, Manas, it has not been submitted in the time frame. That's it.
It is being submitted within 90 days.
That is
Yes. Yes.
that requires to be read in that language, Manas. The appointing authority has not issued such.
Yes, we will allow this writ appeal and we'll let the authority reconsider it. Let the authority reconsider. Let it have the ramification. Yes. No, your endorsement does not speak that it was filed with the higher officer, not before the appointing authority. The reason assigned in your endorsement is it is beyond 90 days. That is expressly wrong. It is not beyond 90 days. Yes. It is required to seek for restoration in services within 90 days from the date of submission of resignation letter. That is wrong. It is not required to seek submission restoration within 90 days from the date of submission of the resignation letter. It is from the giving effective date to that letter of resignation that was given on 27/1/2017, and this representation was given on 24/2017, well within 90 days. Yes. We have seen it so many times, sir, now by this time. Yes. Yes, sir.
Period of absence.
Yes.
Yes. Period of absence.
Yes, sir. Yes, sir. Yes, yes.
Between the date on which the receipt become effective and the date on which the person is allowed to receive the TG, as a result of permission to withdraw resignation for the 50 days. But this case, can you look at it? Who has accepted the resignation? Officer, if he is made submission elsewhere, if it comes through proper channel.
No, that is not the reason assigned by you.
Whereas the reason was said only beyond 90 days was said.
Yes.
That's it.
Yes.
It is beyond 90 days only. You need not to assign the reason is simple.
How it is beyond 90 days, sir, if it is given within that on 21/4/2000?
It has to be given in a proper, if I want to submit an application here, if I submit elsewhere, you can't, for example, I give a classic example. I make an application. Make a submission. It can't be done like that. It has to be done, the rule says that the manner in which it should be done. Nothing is going to be improved because of this reconsideration. Also, reason is this lapse. I cannot make an application according to the rules.
Sir, your officer has forwarded this his representation. Kindly see, he has forwarded this representation on birthday after so many days.
Yes, madam. I just gone to headquarters. So here, please, you have to understand that.
So you will interpret that this 90 days, if it is left to the officers, they will never attend to it. They will never attend to it, sir, within 90 days. Yes, no, that is the interpretation given. They will never attend to it within 90 days.
90 days period, in terms of rules, is not there in this case. You have said in our schedule of application 6, this letter has been submitted in the Delhi headquarters.
No, you are not said so.
No, it is said.
You are not. Your statement of objection is not an endorsement, sir. You cannot put words into the mouth of the officer while writing this statement of objection, which has not been considered and taken by the authority at the relevant point of time. Yes, sir.
Even if it is permitted to be reconsidered.
Yes, sir.
Now what happens? The rule says that it has to be submitted before the appointing authority.
Yes.
Yes. As a matter of application, undisputed fact is that appointing authority has not made an application.
Yes.
That has not been made. That is undisputed fact. I have made an application elsewhere in the office. That is how this considered.
Not elsewhere, sir. He is your own officer. He has forwarded. He has forwarded that to as per Annexure H. Yes, he has forwarded it on 12/5/2017.
Yes, this is only after 27. Not before that. He produced one document saying that even this was
No, when you have received this 21st April 2017 representation. No, but why do you say beyond 90 days? Give the exact date. No, you give the exact date when you have received this representation dated 21st April 2017. That will solve the problem. Either he has produced the acknowledgement, nor you have produced the exact date. No, yes, according to him, it is dated 21/4, but he has not produced any acknowledgement. When you have received it, sir?
This has reached the office on Delhi office when 26/4/2017.
No, where do you get it?
I got the exact 26/4/2017.
All right.
Even then, it is within 90 days.
Para 6 of your statement of objections, page 41. Para 6 of your statement of objections. Page 47. Last sentence.
Yes. His application was received in directors after the expiry of the above period and was thus rejected by the consultant.
It's totally wrong. It is not received after the expiry of the 90 days in the directorate office of the directorate.
It is 27 4 of the filter. So
20 days. Let us file an application.
For 27 for 2000.
Reference date of our rate, January 27.
Reconsider it, sir. Yes. We will say all rights and contentions of the parties are left open. Reconsider. No, it is ex facie. It goes against you as is stated in paragraph 6 of your statement of objections. You have admitted that his resignation was effective with effect from 27/1/2017, and hence under the above provision, he had to have been reinstated before 27/4/2017 on an appeal by cancelling his resignation. His application was received in directorate after expiry of the above period and was thus rejected by the concerned authority. So it was received on 26 according to you. According to you now, it was received.
Was received. Partially, you were able to within 27/4. That's what we are saying.
Yes.
That is distinction.
Yes.
That's a distinction.
Yes.
The rule has to be read. Both action has to happen within the 20 days time. This itself is delivered on 26/4. 27/4 is the last day.
The interpretation now given in your endorsement and the statement of objections is not convincing. Yes. Yes. Yes, we understood it, sir. We understood it.
And this restoration has to happen within 90 days from that date. That is supposedly that we have not made that application before the competent authority.
has reached the directorate within 90 days.
If you had already sent it there, certain you could have said yes, in one day you could have made the order. Yes, elsewhere, that is really such a vast thing. It has to come to the had he addressed this letter to the commander, suddenly he could have taken them to stand. He was aware, he knows who is this funding authority, where he has sent the resignation. These are the material things will be discussed elsewhere. When you look at the way he has sent it, you have got all sympathy with him. I am not saying how I mean, we do not need to go back. That is also because to be this application to the appointment. Had he been, has he got to give a right to say? But you have taken a decision order to be in comes with the rules. So what have to look this way? It has to be.
Your endorsement is also not, your endorsement is not clear on that point. It does not speak that you are not forwarded your representation to the appointing authority, or yes, all that is not there.
That may be regarded. Because is it going to be a good express? Something I cannot say beyond it. Whether it is going to be a good, now in the absence of those reasons, then they will write all the reasons.
Yes, that is what they are required to write all the reasons. That's all.
That will be observed and
Let them give all the reasons.
yes.
Not only this 90 days, let them give. They have done the counseling also.
Yes.
They have made it very clear to that
Yes.
to the appellant about this unemployment problems. And yes, yes. Despite that, he has volunteered to give the.
You have not
Yes.
stated that in order to avoid a posting,
Yes.
he had given it.
Yes.
That is not
Yes.
the reason.
And he insisted that the post only at Delhi or at Bangalore. Yes, all that you would have explained in your endorsement.
There are two aspects. Now,
Yes.
endorsement is considered only one aspect.
Yes,
Whether it was before the comment authority. Secondly,
all that has not come in the endorsement. Let them give the reasons. There are so many reasons. There are so many reasons. He opted only for Bangalore or Delhi.
no, that is not the issue. When we look at the 60, that is subsequent thing. Try to look at whether
And after receiving this representation for this, after receiving this resignation, as counseling was done, it was explained to him the financial hardship that he may face.
Before lines were not well undertaken is given. I actually called me and explained me the growing unemployment problems prevailing in the society and the likely financial uncertainty economic age after quitting service. However, I still insist and wish to proceed on discharge from service on my own request and interest due to domestic problems, and there is no pressure upon me to resign from service. I undertake to say that I will not withdraw the resignation under any circumstances whatsoever thereof. I further that as I insist on proceeding on discharge with immediate effect, I should not insist for immediate receipt of my present dues and shall bear with the delay whatsoever happens here in receipt of my present dues. Now, reasons will happen. Islam court says that
A reason should be given, proper reasons should be given. You may be having good case, but reasons are not forthcoming. There are so many reasons. And he has given undertaking that he will not withdraw this notice for resignation from service at a later stage. That is also one point. Only thing is you said 90 days. 90 days, it's not from the date of submission of the resignation letter. That is wrong. It is from the effective date. Yes, it should be clear, sir. Yes. So it is not from the, we will make it clear because in future it should not be considered as from the date of submission of the resignation. It is from the date of giving effective date for that resignation. Yes. Yes, that all that you take out. You take out all that for the reasons. Yes. But it is not forthcoming in the endorsement. Yes, we will record it. We will record all your submissions. But all these submissions are not forthcoming. We have also observed all this counseling done and he has given all the undertaking, all that is not forthcoming. Yes. Let the reasons be given, proper reasons be given by them. The matter has to be remanded to which authority? No, the
Second respondent.
No. This annexure J is issued by whom?
Second respondent.
Respondent number 2, no?
Second respondent.
Appeal is allowed in part D. Order of the learned single judge dated 15 July 2019 is set aside and the matter is remanded to the respondent number 2 to reconsider the matter and pass appropriate orders in accordance with law by giving by passing and pass appropriate speaking order, giving cogent reasons for taking a decision in the matter. In accordance with law. And the complaints shall be made and such complaints shall be made as expeditiously as possible. Thank you for letting me. Since
3 months from the
learned
date of
counsel
order.
appearing for the court or represented by the learned counsel, apparent is permitted to appear before the respondent number 2.
There is no hearing.
No hearing.
There is no hearing. Only 30 days alone.
Within period of 3 months from the date of submission of the order, receipt of the order.
Since expeditiously as possible, preferably within a period of
3 months.
Why do you need?
You got good grounds. Why do you need 4 months? Within a period of 3 months from the date of the receipt of the certified copy of the order. If you have cogent reasons for arriving at a decision, it's not a speaking order, and it's actually it goes against this, not from the date of the submission of the resignation letter. Yes, we will give the reasons. It is not from that. You will record your submissions also.
Obliged, my lord.
And no one can seek for any place. Because transfer is an incidence of service. They cannot seek that I want only in Delhi, I want only in Bengaluru.
My lord, I'm for the appellant, my lord. Grant a week's time, my lord.
List the matter by next week at the request of the London Council for the appellant.
It's on
Yes. Yes, Ashok Narayan Nayak. What is the matter, sir?
Yes, my lord. The dictation of prayer and recovery. Learn single day that last recovery is concerned. Claim of the
ಅಜ್ಜನಾಗಿದೆ. Ashok Narayan Nayak. None appears for the appellant. This is the matter by next week. Yes, sir.
50 I appear for the petitioner, madam. I appear.
Yes, sir.
Serial number 50, my lord, I appear for the petitioner.
Yes, sir. Kindly make your submission, sir.
Yes, my lord. My lord, in this matter, the labor court, my lord, the respondent caused an accident, my lord. Caused an accident resulting in 2 employees, my lord, they sustained serious injuries inside the bus stand. For which, my lord, an article of charge was issued, inquiry was conducted, and thereafter, my lord, the punishment was imposed. Punishment, my lord, of reducing basic pay of the respondent permanently to the minimum was imposed. Well, thereafter, my lord, he approached the labor court. The labor court held that the domestic inquiry was fair and proper. And my lord, the fair and proper rejected the dispute. My lord, this honorable court, my lord, my lord may request my lord to the single judge's order, my lord, page 19. Page 9, my lord. Sorry, 9, my lord.
Yes.
9, my lord. My lord, this honorable court comes to the conclusion, my lord, is saying that my lord, page 40, my lord, page 14, 13, my lord, 13, my lord.
Yes, sir.
My lord, may I read that portion from para 6, my lord? Arising out of the accident. May I read that, my lord?
Causing accident, it has resulted in the of staff of a respondent. Recently, judgment has come, causing accident.
Yes.
The driver, okay, by the case service driver. Recent, last week, one judgment has been rendered.
Yes.
Same issue.
Where my lord, in the criminal case, it was not an honorable acquittal. And thereafter, my lord, this court comes to the conclusion that the management had not led evidence. That is why I am setting aside the labor court award. In fact, my lord, the employee, he did not lead evidence. May I take my lord's attention, my lord, to the labor court award, my lord? My lord, page 27, my lord. Page 27. the labor court comes to the conclusion. Page
Yes, what
20.
is page? You are ready? Yes, yes.
Witnesses are not ever witness said into this. Nobody says that he's not the accident.
Jude.
Himself says he does not know about accident. He is the company. Service. Is also not complete the job sheet. To by the but only based on FIR of both.
So, in the absence of corroborative evidence and any eyewitnesses, one cannot draw inference that there was negligence on the part of the petitioner in causing accident. This is the view expressed by the learned single judge.
May page 27, my lord.
Yes, sir, page 27.
May I read that, my lord, in the middle paragraph? The accident is not in dispute. My lord, about 7 lines from below, my lord, from top, my lord. The accident is not in dispute.
So, what you are reading? Article of charges, huh?
How this one? The accident is not so. It is the workman to
page
show.
Page number 27, sir. It is in Kannada.
No,
that is the internal page.
Internal page. Internal page 5.
5 of annexure.
My lord, that is the award, my lord. Annexure E. 49. I'm sorry, my lord. 49, my lord. 49. Sorry.
It starts from page 45. Yes, sir.
Yes, 49. 49. About 6 lines below, my lord. The accident is not in dispute. So it is the workman to show that the accident was not because of his negligence, but it was because of some other cause. Here, in this case, the workman has not at all produced any piece of evidence, either oral or document evidence, to establish his defense that the accident occurred in his absence. And as contended and his reply to the charge sheet, the workman has not even ventured to enter into the witness box and stand the test of cross-examination. When that is so, finding of the inquiry authority placed at Exhibit M21 is comparison with the other inquiry records make it very clear that the inquiry authority clearly appreciated the facts and evidence placed before him and recorded the finding, holding that the workman prima facie guilty of the misconduct. Though the workman received an order of acquittal in the criminal case lodged against him in so-and-so, the file, so as could be seen from Exhibit 24, he was not totally exonerated from the allegation of negligence. It is only said that he is entitled on the benefit of doubt. Accordingly, receiving the benefit of doubt, he has got the order of acquittal. So it is clear certainty of records on the file doesn't make it clear that the inquiry finding in no way can be termed as either perverse or illegal. The accident was cause of the death of one employee of the depot, and also it was the case for one more employee to sustain injuries. One more important aspect is to be kept in mind is that the accident took place very much inside the premises of the depot, subjecting the bus to repair work, and it was washed on the washing ramp. Keeping these aspects in view, you might consider it is clear that the punishment order reducing the basic salary to the minimum basic is clearly justified and absolutely interference is unwarranted. My lord, instead of taking this, my lord, the honorable single judge goes to the conclusion saying that the management has not led. In fact, we have led the evidence before the inquiry. Inquiry has been held to be fair and proper, and all those records are taken into the record. On the other side, the workman does not lead any evidence. The court, the single judge, my lord, comes to the conclusion that there is no evidence from the management. In the absence of corroborative evidence, something is not there. And it is not a case of dismissal or anything, my lord. It is only reducing the pay.
There is a recent judgment of this court. Have you gone through it, sir?
No, my lord. No. Of my lord, my lord.
Not of this bench. From the bench, I read it.
I'll go through, my lord. If my lord could take it up tomorrow, my lord, I'll find out the file. It is in fact in my favor. There is a judgment of the Honorable Supreme Court also, my lord, that
No. I mean, I read it. Repeat it tomorrow. Kindly make some effort to see this. Whether
tomorrow itself I'll produce some judgments also.
Yes, release the matter tomorrow. You also make some efforts, sir. Please. Yeah. But you have not appeared before the labor court. But for the cross-examination, you not tendered yourself for the cross. The management has not examined any witness.
They are not.
Yes, but yes.
Lord, the question of evidence does not arise. The inquiry was held to be fair and proper. Inquiry was held to be fair and proper. The question does not arise at all. But here, before the inquiry also, he does not lead any evidence.
But he submits that before the inquiry officer, yes, let in evidence.
No, my lord, that is the findings of the labor court. I will produce the document. Tomorrow I will produce the document.
Have you appeared before the inquiry officer and you are let in evidence? Yes. Now, what is the observation of the learned single judge?
Learned single judge, my lord, goes the other way around, my lord. Page 13. 13, my lord, internal page 5.
Yes.
Perusal of the order imposing penalty as well as the award of the tribunal. It is evident that there is no iota of evidence to contend there is a negligence on the part of the petitioner in causing accident which has resulted in death of a staff of the respondent. In the absence of corroborative evidence and any witness, one cannot draw interfere that there was a negligence on the part of the petitioner causing. Management has failed to produce the evidence of any person and not even evidence of injured person so as to contend that there is negligence on the part of the petitioner which has attracted misconduct.
Because the petition is on the other hand, labor court has observed that the workman has not even ventured to enter into the witness box.
Yes, ma'am.
And stand the test of cross-examination.
Yes, ma'am. Yes. I don't know where the honorable judge gets all this, he passes on.
In the affirmative, right? Once that is done, preliminary issue has been held in the affirmative. Once that is done, whatever evidence recorded before the inquiry officer continues to be evidence. Its burden is on the workman to disprove that.
Now here, what are the issues framed? First issue is whether the domestic inquiry conducted by the respondent management against the first party is fair and proper. So
Yes.
what is the answer to that question?
Fair and proper.
It's a presumptive misconduct.
It is that.
Accident, it's a presumptive misconduct. Unless you disprove, you'll be held.
The first issue is held in favor of the management member.
Whether records are called.
No, my lord, records are not called. Records may be called, my lord.
By virtue of the punishment,
My
how
lord.
many increments he lost?
My lord, permanently, my lord, only
How
1
many
year.
increments he has lost? Permanent is there.
In fact, my lord, the punishment also is,
No, it is reducing the basic pay to the minimum basic pay.
minimum pay.
Reducing the basic pay to the minimum basic pay permanently.
Permanently.
Yes.
Stagnating.
That can be modified or.
Shall we release the matter tomorrow?
Yes, my lord.
Find out the judgment.
Oblige, my lord. I do.
Yes.
Appear for the respondent, first respondent.
Release the matter tomorrow.
Appear for the first respondent.
Yes, sir. Where is the appellant counsel, Mr. Mahesha? It's also 2:30. We'll continue.
Yes.
My lord, 52 may I request for about a week's time, my lord. Next matter.
I appear for the petitioner.
Senior counsel, Mr. Ramdas had to argue he had some personal inconvenience. He had to leave. May I request on 15th or 16th, my lord?
So kindly see the number of adjournments taken.
In fact, senior
Is
advocate,
the
my
matter
lord, last time
relating to
took the
recruitment to
adjournment.
a
I did not-
scheduled
I was
tribe
ready.
post? And the matter is being dragged on for the last 3 years.
My lord, last time they only took time, my lord. We did not take time. We were ready.
Sorry.
But 15th or 16th, he had
Kindly
some,
see
he
the
has some
order sheet.
personal inconvenience
Anyway,
today, Mr.
I have
Ramdas.
no objection if he has inconvenience. Kindly take it up tomorrow. There is some urgency in the matter.
Tomorrow, yes.
Is it convenient for the learned senior counsel?
My
If
lord,
it is
may I
taken
request on
tomorrow, sir?
15th or 16th, my lord? May I request, my lord? Some family issues.
The other side is objective.
If I may
to
request,
that.
my lord, senior advocate also for either 15th or 16th, because Ramdas sir had to.
Anytime this week, anytime this week, anytime this week, not next week. Anytime this week.
Tomorrow, 8th or 9th.
My lord, may I have it on 9th, please, my lord. I will
please
inform senior.
Other than 9th. The request of the learned counsel for their time.
Grateful, please.
Court officer.
Court officer, sir.
Court